She has been found to be eligible for being appointed by the District Inspector of Schools, Secondary Education, Purbo Mednipur, and the same was communicated to the West Bengal Regional School Service Commission with a communicating memo dated 18th March 2025. The petitioner alleges that since thereafter, no steps have been taken by the authority. Stop. Learned advocate representing the commission seeks time to revert with instruction. Next Friday?
No, 2 weeks. 2 weeks. Because this selection process is going on. All the staffs are there in the central commission. It is Western.
Passionate appointment.
Corporation, 2 weeks, I will come back. Otherwise,
come back when?
After 2 weeks.
2 weeks?
When Friday.
Today is 28th. Next Friday is 5th. I keep it on the 9th. 9th. December.
Great.
As urgent motion.
আমারটা দিয়েছে তো
রেসপন্ডেন্ট নম্বর 23 কমল মিশ্র রেসপন্ডেন্ট নম্বর 10
আমারটা দিও
রেসপন্ডেন্ট নম্বর
কমলদার নাম
Yes.
I'm for the petitioner, my lord. The petitioner is an in-service teacher in right now currently in service, my lord. She has been recruited through 1st SLST 2016 for the classes 11-12, and due to, my lord, wrongful and deliberate action by the commission, she has been deprived from. She had been abstained from joining her post in 2019, my lord. Kindly see the order.
What is your prayer?
My lord, to give my experience from 2019, my lord. She has been.
You work ever?
Yes, my lord.
When?
From 2022, I could join the post because before that, 2 persons had been wrongfully appointed in my post. Kindly see the order, my lord, of 46 page.
When did you join practically?
My lord, I could join in 2022, my lord.
And you want notional benefit to be given for experience?
Because my lord, I could not join due to
right.
commission.
You could not join. This is an admitted fact.
I could not join, my lord.
Could not join. This
because
is an admitted.
In my post.
Not the because. It is admitted you could not join. How did you gain experience if you did not join?
My lord, kindly see page 46 once, my lord.
Tell me, madam, how you can gain experience.
I had been deprived, my lord.
Madam, I want to know how you gain experience.
My lord, my experience was enjoyed by someone else.
Right. So you did not gain the experience. Somebody else will get the experience, Mark. How can you get?
My lord, kindly see page 46 once.
Want to get ready? Some more judgments?
Yes, my lord.
I think, my lord.
Kindly see page 46 one.
No. You want to revert next day?
Yes, my lord.
When will you come back?
1 week. 10th, my lord, 10th.
Right. To allow the learned advocate.
May she consider this order of your lordship, my lord?
I am aware. I'm aware of the order, my lord.
That is the reason.
But
you please come
today,
ready.
my lord. Today, my lord. Kindly see one submission.
I will not say anything. Acha, to allow the learned advocate appearing on behalf of the petitioner to come ready with further necessary instruction released on 10th. 10th?
All right, my lord.
10th. Next. What is the use if the are dismissing it today and dismissing it 2 days after?
8 to 11 is central.
Yes, next one, please.
8 to 11, same. Central government teaching fragmented service.
8 to 11.
Same, similar issues.
All right.
Central
government teachers.
Central government, my lord, fragmented service, not continuous. I am covered by your lordship's order in Priyanka Shaw.
All right. Yes.
My lord, I am led by MD Sarwat Jahan. So, my lord, I am praying for not today.
Only not today?
Only not today.
Not on 10th?
10th.
No, let it be on 10th.
10th.
8 to 11 on 10th.
Same matter. Same matter.
On the prayer of the learned advocate representing the petitioner, release the matter on 10th.
My lord, 29 to
Item
30.
11, my lord, I am appearing.
Number also same. Saniullah number.
8 to 11.
8 to 11.
In 11, my lord, I am appearing on behalf of state.
All right. 8 to 11 then.
29 to 33.
Are you aware?
Yes,
29 to 33.
29, just give me 2 minutes. 29 to 33, my lord. Yes, we are aware.
37 to 38.
37, 38.
30.
So all are being adjourned till 10th.
29 to
No, 29th to
Yes, next.
33. 37, 38.
সব 10th আর 8 থেকে 11 হ্যাঁ হ্যাঁ নামগুলো দিয়ে দে
Grateful.
12.
12 is a tainted candidate of group C subject to correction.
Yes, let me see. Yes. Right. Yes. What is the matter?
দাঁড়া, দাঁড়া, দাঁড়া। 66
One of the petitioner allegedly tainted candidate.
12
Kindly turn page number 42.
Yes.
The first page of this notification is start from page number 39.
29 to 33.
This notice, because this is a bulky notice, so the relevant page as well as the first page. In compliance with the direction of Honorable Justice such and such, dated such and such, WPA number such and such, differences of marks of total 3,478 candidates in connection with third RLST NT, that means non-teaching, 2016 have been published in the website of West Bengal Central School Service Commission in 13 March 2023. Here, my lord, 6 columns are there. Applicants' names are there. Applicants' roll number also there. Published OMR marks is also there. Actual OMR marks is there, and differences of marks is there. In each and every column, marks is there. Kindly turn, my lord, page number 42.
44.
42.
42.
This is a petitioner, entry number 2442. Sheikh Shaniullah. Got it, my lord?
Yes.
Petitioner's names are there. Thereafter, my roll number, marks 54. Thereafter, column is blank. Got it, my lord?
Yes.
After this blank column, my lord,
কি দেখালি page 41
42.
40
2.
serial number হ্যাঁ
Four, four.
এটা blank
Thereafter, my lord, I made a representation before the chairman, West Bengal Central School Service Commission. In the year 2023 itself,
Submitted blank.
I just read it, my lord. আমি শেখ সানেউল্লাহ 2018 সালে ক্লার্ক পদে জয়েনিং করেছিলাম। আমার অ্যাডমিট কার্ডে রোল নাম্বার গত 9/3/2023 তারিখে মহামান্য হাইকোর্টের নির্দেশে এসএসসি যে ওএমআর প্রকাশ করেছিল তাতে আমার সিরিয়াল নাম্বার ছিল 2512, কিন্তু এসএসসি ওয়েবসাইটে আমার ওএমআরটি দেখতে পাচ্ছি না। পেজ নট ফাউন্ড, দ্য রিসোর্স ইউ আর লুকিং ফর হ্যাজ বিন রিমুভড অর টেম্পোরারি আনঅ্যাভেলেবল দেখাচ্ছে। গত 13/3/2023 মহামান্য হাইকোর্টের নির্দেশে এসএসসি যে মার্কস ডিটেলস দেখানো হয়েছে তাতে আমার সিরিয়াল নাম্বার ছিল 2442। সেখানে আমার মূল ওএমআর মূল্যায়ন নাম্বার 54, বাকি জায়গায় ফাঁকা রাখা হয়েছে। দ্যাট মিনস হোয়াট ইজ দ্য ওএমআর মার্কস। মহামান্য হাইকোর্টের নির্দেশ ছিল প্রার্থীর প্রথম ওএমআর প্রকাশ করতে হবে, তারপর নাম্বার দেখানো। যদি কোনো অসঙ্গতি লক্ষ্য করা যায় তখন প্রার্থী বাতিল, কিন্তু আমাকে আমার কোনো কিছু না দেখিয়ে বাতিল করা হয়েছে। মহাশয়, আপনার নিকট আমার বিনীত নিবেদন, আপনি আমার সমস্যাটি সমাধান করিয়া দিলে বাধিত হইব। In the year 2023, I itself made this representation. Very next page, and each and every representation is received by the SSC. Kindly in bottom there is a very next page, another representation. Very next page, I made an RTI application. Page number 47. In the year 2024, I made this RTI application for getting the OMR sheet. Because in the column, there is no such mentioning of marks. I am the only candidate among 3,478 candidates whose marks and OMR sheet never disclosed by the SSC. In this writ petition, my lord, I made the party, the CBI also I made the party. Supply me my OMR sheet, published it, and not only that, my lord, there is a specific direction of the High Court Division Bench, my lord. Publish the OMR sheet of all the candidates for public viewing. Till date, I made the RTI application, not get yet. I made the representation why I am a tainted candidate. They never disclosed it. So, in the respect of that, my lord, why I before this court, my lord, recently, my lord, they floated the first SLST 2025 advertisement, my lord. The last date of online application is 3rd December 2025. So if I am eligible one, if they wrongly put me in the tainted list, my tainted list is also annexed with my petition, page number 90. They put me in the tainted list without disclosing my details.
All right. Yes.
You know,
Is anybody there on screen?
no.
No? You'll be, yes.
Lord, page 42, it is blank on instructions I am submitting, my lord. On instructions, of course, oral instructions. I cannot give your lordship anything in writing. This is a 2016 process, my lord, culminated in the judgment. Then Supreme Court, a lot of things have happened. Lord, my instruction is he has submitted a blank OMR. That is on instructions, my lord, oral. I cannot give you a lordship.
He made so many representations.
But he,
Why did you not communicate that the OMR was,
The OMR.
why don't you publish the OMR in
Yes.
the website? He gets to know that it was blank and everybody else also gets to know.
And that is
Opportunity to inspect.
No.
my lord, my instruction is, my lord, in pursuance of the division bench's order, my lord, Justice, I'm not naming on the honorable judge, my lord, he was permitted to inspect his OMR, which according to our instructions, he did not inspect. That is on instructions, my lord. If your lordship intends, my lord, we'll come back with a written instruction.
Doesn't matter. Just upload it. You'll get to know what is there.
give specific direction, my lord. My lord,
Upload.
OMR টাকে upload করতে বলছে। আছে? We have destroyed it.
Why will you
We'll have to take instructions on this. My lord, allow me to come back on Monday or my lord on Wednesday.
yes, my lord,
last
first
day
day
is
is the third.
date of filling up the application forms. Urgency has cropped up only for this reason because 23 this was published and he has annexed documents to show that continuous.
Allow me to come back at 1 o'clock. Orko.
Yes, prior to rising in the morning.
In the morning session.
Mornings.
I want my OMR sheet. If
All
blanks, give it.
All right.
দেখছি চেষ্টা আমি তো এতদিন বাদে ভট করে
Next.
মামলা করে
Obey the order is division means order is long.
13 minute we don't have any copy. It is not uploaded anywhere. 13. I do not know whether it's a SSC matter. SSC.
Mr. Onyo Bhattacharya, for the petitioner, he in the midst of argument will kono 13 or pass formal.
Passover.
Pass formal. Short pass formal.
I can see the Central School Service Commission as party.
Milord, we have not been officially, of course, Milord, it is not,
Secondary education also.
Milord,
as party.
it is not uploaded in the system. Otherwise, we can't
Alright.
get access. Milord, Sharthak is not there.
Oh, yes, sir. Yes.
Milord, may a copy of the writ petition, if it can be served.
Petitioner.
I am.
Did you serve?
Yes.
Chairman has not been served.
Yes, it is served by post and also.
That post, nobody will get the,
And Amar Mr. Nag also it is handed over, my lord.
Mr. Nag.
Yes, it is handed over to him.
13 নম্বর মামলা
If at least soft copy was served.
No.
Nothing, no copy served.
No.
Milord, why will we not, Milord?
Yes.
এই কাজ সরিয়ে দেখাচ্ছে রে ভাই
Oshik. Sir, Oshik, I cannot read for KK Singh.
एक is.
No.
Nag.
Rahul Singh.
Please check, somebody has.
Milord, may the issue be,
What is the matter?
This is a matter where I'm the ABC, I'm a OBC B candidate. Now, the marks obtained candidate on page 3130.
You have an extra copy with you?
Yes.
Please give it to Mr. Bhattacharya.
Total, very big. My lord, your lordship kindly turns to page 30. 30.
Yes.
That I am a OBCB candidate where my lord, I obtained 56.
Page 30 shows category general.
I cannot be because my lord, that is why my lord, I wanted to place 2 pages only. Page 30, kindly have a look. Page 30 says, my lord, the total marks I have obtained is 56. The cut-off marks in the above mentioned vacancy particular 62. My lord, got it? Now your lordship kindly turns to page 34. This is the interesting part.
Yes.
Serial number 3, Debjani Dotto. Sorry, Debolina. আমি কি
দেবযানী দেবযানী দত্ত।
Eh,
না না
দেবলীনা দত্ত,
দেবলীনা।
দেবযানী দত্ত।
দেবজিনী
আহ।
কোথায়? দেবজানি কোথায়? But I was mistaken. I was mistaken. I made a representation.
Where page 34 there is no Debjani.
No. My can I have a look to my representation once?
Why have you annexed page 34? Why? Is dismiss. This
No.
cannot be done. No. If you mix up Debolina with Debjani, then how can you?
I was also confused.
চলে গেছে দিকটা, আমি দেখাতে পাচ্ছি।
What?
May I get a short pass over for 2 minutes?
Prior to rising. First session.
Monday. Well, we have just received.
No, better.
Monday. Take this back.
এই চিঠিটা ফেরত নাও,
ফেরত দিয়ে
চিঠিটা
দেবেন
ফেরত
তো?
নাও।
ভুল নয়, সে দেখালে
সোমবার।
একটু ছুটে যাই, আমাকে একটু ঠিক কালি।
My lord, I beg to state on behalf of the petitioner in this matter, this is regarding the mismatch in the model answer key. My lord, subject is nutrition, 3 questions. There could be 2 answers from the textbook. 1 answer has been taken by the commission. One question is completely erroneous. I will not take your lordship. Just one example, that what is the circumference of arm of a school-going child below 5 years? The book says the school-going child has to be 6 years onwards. The question itself is wrong because 5 years child is a different circumference of the arm length. 6 years above children have different, those are school-going. Absolutely wrong answer. So it cannot evaluate my merit on that. And lastly, my lord, one question, it says all of the above answers are correct. Option A, 1 answer, option B, option C, option D. Option D says all of the above answers are correct. So by dint of which, if I mark A should also be correct, B should also be correct, C should also be correct. No, they have said A and D are correct, despite they have taken that all of the answers are correct. So my lord, 6 questions, few have left out, could not qualify the cutoff for this, and few have been, though have qualified, but they are in the below rank. Now, my lord, we raised objection after publication of the preliminary model answer key. Kindly come to page
Which
19.
stamp you have paid?
Yes, I paid the stamp duties.
Deficit?
Yes. Yes, my lord, I subject
There are
correction.
24 petitioners, each has a different case.
No,
Each has a different problem.
no, same problem.
Correction.
No, same problem with 6 questions. That is why I have come. My lord, kindly come.
24.
They all have the same problem. 3 questions are already in, 4 questions are already 2 options given. 2 can be correct, 1 has been taken from the textbooks. They all lose out on that. One question is absolutely wrong for all of them. One question says all of the answers are correct, above A, B, C are correct. They have missed out on that. Those who have marked B, he has missed out. Those who have marked A has passed. But if all of the above answers are correct, you cannot say the no, option D is correct answer. You cannot say.
When you mark B, that means only 1 is correct.
It says all of the aboves are correct. A, B, C, all are correct. When I mark B, so according to D, all B is also correct.
No, but then according to you, A is not correct.
No, all are correct. Now D, which says all of the above, who has only marked D has been giving the marks, not A, B, C.
Obviously.
They have not been. Now A is also correct. Now it says what is the main purpose of midday meal? The main purpose is to stop.
Whatever.
Yes, I'm not going.
Looking into the
Now, my lord,
questions
kindly come to
and
page
answers.
192 for once.
192.
Oh, this is volume 2. Volume 2.
192.
Volume 2 of page of,
Yes, 192.
these are the objections raised after publication of the preliminary model answer key. We raised the objections along with the books. We paid the fees also. We uploaded the PDF copies of the books, textbooks, which are approved. Now, my lord, after that, we also, after the publication of the final answer and the model answer key, page 376 onwards of the volume 3, we have lodged complaint again that you have not changed this, corrected this. No step has been taken regarding these 6 questions.
These 6 questions, after you raised objection in the first stage,
Yes.
there has been no change.
In in one question only,
There has been a change.
yes, only one question. B was the option. They made it A and B,
Whatever.
which is the wrong question. Which is the wrong question itself.
So one has been at least taken care of. Whether it is
Not even
wrong,
taken. It is altogether a wrong question itself. The school-going children cannot be below 5 years. It has to be 6 to 12. The question is itself wrong. And this question 5. No. The textbooks clearly says otherwise. Now, Malwa, I have all the records of the textbooks. We have uploaded also. They ought to have taken a decision on that. That whether my objections are correct. And Malwa, your
So you all
lordship
have
has
taken
passed.
decision or not?
Yeah, this is your lordship's order. Last
Yeah,
session.
the other matter is there was a
straight.
direction for filing a report to disclose how you have considered the objections. Come up with that only.
And Malwa,
That matter is coming up perhaps on the
Wait, no, this is 3rd December. 3rd December. 3rd December.
3rd of December,
But-
one order has. Let this.
And my lord, there is a protection given in that order that subject to the result of the writ petition. Because my lord, if I lose out, I cannot qualify. I lose my opportunities.
How much marks short?
Differently, if you have 1, if you have 2, if you have 3, 1.
Why did you join together?
Same
24
question.
petitions, it's not
Same
a
questions.
question.
No, it is-
Pardons are
We all lost the complaint, my lord.
the
It is
24
same
petitions,
questions.
the
We are
same
accused by
petition,
same
they
questions.
cannot be on the same board.
This can be, my lord. We are all aggrieved on the same questions.
I give you 1 week more. 10th.
10th. My lord,
And it was abide by, my lord, right.
my lord, all 20. My lord, only.
My lord, I stand corrected.
24 writ petitioners, 19 have furnished objections.
Rest did not.
Rest.
No, they raised in 2 ways. 2 ways. First preliminary objection, then final objection.
Not final. Preliminary stage, if you have raised
Preliminary 19 have given.
they'll consider themselves with the 19.
Only those 19.
Only those 19
But
who
your lordship
filed-
desires, my lord, of
objection.
us, my lord, as
How
to how
it
we
has
have considered the objection.
Right. Absolutely. The petitioner has participated. এখানে. Hmm. একটা প্যারাগ্রাফ অ্যাড আপ করুন তো। The writ petition has been filed by 24 petitioners. Just check up. Deficit court
No,
fees.
I'm yet to pay, my lord. Kindly allow me to pay by today.
Then your lordship will
By
keep-
today, in course of today, I undertake to pay.
24 petitioners have filed
One
an
has been
instant writ petition
Vote
by submitting only one
Joyce,
fees. Stop.
vote আমি দিয়ে দিচ্ছি।
Let deficit court fee in respect of 23 petitioners be deposited in the course of the day.
In course of the day, yes.
In the event the same, in default, the order passed herein will be restricted only in respect of the petitioner number 1, and the writ petition shall be deemed to have been dismissed in respect of the others. Stop. Next. The petitioners participated. এটা এখানে থাকবে। Secondly, the he যেখানে রয়েছে, please take note. 19 out of the 24 petitioners
19. Sure.
raised objection
নামগুলো দেখো।
in the official portal.
মেলাও তো এখান থেকে মেলাও। সৌম্যদীপ।
The issue pointed out by the petitioners, issues are allegedly not rectified.
সৌম্যদীপ, দীপিকা, মণিকাঞ্চন, এর মধ্যে নেই 24 নম্বরে লেখো মণিকাঞ্চন। এখানটা লিখে রাখো না মণিকা।
No.
16 is fragmented. 18, 19 are two rules.
The protection, your lordship, last paragraph.
Service is taken off record.
But there are 2 types. My lord, few have not qualified and few have qualified. And the 4th December is their verification. So accordingly, my lord, the protection may be given.
The protection is blank for everybody. It's
Very well. Very well.
and the paragraph where the verification of credentials is there, that has been deleted. I'm deleting it because I'm placing it on the 10th.
Very well. 4th is the date, my lord. 4th is the
Doesn't matter.
verification.
The interim protection is there.
Very well. Grateful, grateful to Lord. They ought to have considered at least my objection.
Next. I get to dispose now.
I was wondering, if one affidavit, I was wondering if one person has filed an affidavit for 24 persons.
Check up what is
Just
the
give me 2 minutes.
rural portion next day, you say.
Rural portion, it says one, it is only one. Shomodip Panigrahi on behalf of all. How can,
Yes, that is how we
how
do.
can one
Know the
assume the
facts
case
of
of
the
the other?
others.
It has to be
Depends.
other affidavit.
6 questions.
But
Same
You
questions.
can know the
That
facts
is
of
how we have
Right,
filed other
or-
petitions also.
The next day I'll see. Yes. Item
No, 6
15.
questions we are agreeing.
minute I appear. I appear for the petition.
Yes.
15 minutes
But kindly turns to be 30.
covered by your lordship's order.
But experience mark has not been given.
Yes.
But I was an approved teacher. Page 20 is my approval. Since 2019, my lord, I was discharging my duty as an assistant teacher
Of
of a government sponsored school. My approval has been given by the DI. Page 20. My lord, got it? My lord, because of the order of the judgment of the Supreme Court, my lord, I lost my I lost my job. Now your lordship kindly turns to page 30.
yes.
But the experience portion
0.
is 0. But the total marks I obtained is 62. But the educational qualification score I obtained.
All right. Then what? What do you want? Experience marks?
Yes.
Where is your application form?
But
26.
page 26. Kindly have a look.
Filled up your details of the experience.
But kindly see, kindly have a look to page 26 once.
I am at page 26. Where is
Yes.
your experience?
But this form, there is no column.
Pardons me, Milord.
It is the
Please see
same
27, Milord. He has filled up the form for 9, 10 with the column, Milord,
Experience.
with the experience.
Yes.
And I am covered by your Lord, Milord. If he has chosen
Page-
not to,
Page 27. Experience I have said, 6
giving
years.
option was given.
Yes.
If page 27 you could fill up 6 years, why in page 26 this could not be filled up?
But the kindly have a look to page 26 and 27 once.
Yes.
But the experience is not there. Page in 26.
The submission of the commission is that if you fill up, it will show. If you don't fill up, it will not be reflected in the application form.
Kindly give me 1 second time.
Get prepared. I'm in no hurry.
Very well. Very well.
When?
We are coming on Monday.
Monday. Check up the order that the commission relies upon.
WP number
26534 of 25 Jhorna Biswas.
26654.
Not today.
26534
26534.
of 25.
Very well.
Next.
Next also.
I'm great.
Next also.
But next is same we are coming on Monday.
Monday.
No, that is fragmented service. That is not, Milord.
Monday.
Wait, Monday I'm coming. Well.
16 Monday. 17 is not.
My lord, I am for the petition.
Yes.
Now, my lord, initially, my lord, my CPF conversion CPF to GPF was not taken up for.
Other side.
My lord, yesterday the matter was called on. Other side was not there.
Who is the other side?
Sanghamitra Nandi.
She was here in the morning.
My lord, I rang, but he is not responding anything.
She must be in court. That is the reason. There must be a clerk or somebody.
Yesterday the matter was also called.
Yes, but then call her. What is your prayer? What is your prayer?
Now, my lord, up to Supreme Court, then Supreme Court directed this authority to accept my option. And after accepting the option, my lord, the PPO was issued. I am getting regular pension. There is no problem on that. Now, my lord, the Provident Fund has been released. I retired in 2007. I am praying, my lord, since 2007 to 2023, the PPO was issued. My interest has not been given. That is my prayer. That too, I have, my lord, made a representation.
Page.
39.
You want that to be considered?
My lord, no.
Please come. The petitioner prays for consideration of the representation.
My lord, only one aspect, my lord.
But then
Kindly-
this is before the headmistress.
Yes, then, my lord, kindly have a look. Page 37.
What is 38?
38 is the headmistress, a district inspector of schools.
Yes.
38. Then headmistress. Everybody I have wrote. 37,
And to
38.
the DPPG, there is nothing.
My lord, interest has to be given by the treasury, not the DPP.
Whether it was the petitioner
Only one aspect,
is
my lord.
aggrieved as he received his Provident Fund dues long after his retirement. So he prays for interest on account of delayed payment of Provident Fund. Yes, sir. The representation made by the petitioner before the District Inspector of Schools, Secondary Education, Purva Medinipur, is pending consideration for a considerable period of time. So, without entering into the merit of the same, the instant writ petition stands disposed of by directing the DI to consider and dispose of the said representation strictly in accordance with law at the earliest, but positively within a period of 12 weeks from the date of communication of this order. If it appears that there has been delay in disbursing the Provident Fund dues of the petitioner, then interest at the rate of 5% shall be allowed on and from the date the Provident Fund fell due to the petitioner till the date of actual payment. The payment of interest, if any, shall be made without any further delay.
Grateful, my lord.
Service is taken on record.
আরে আমার মামলা চলছিল
কোনটা কেটে দাও, তাকে
করবো এটা নেবেন তো
কোনটা কেটে দিলে
ওখানেও জুনিয়র নেই কি বলবো বলো তো
Lordship may kindly first see this Supreme Court's order,
Yes,
because
been brought to the
now
notice
it is entirety by your Lordship.
The order is very important, my lord, for our purpose. Let me place the order. Let's keep over the first paragraph because that was withdrawal. And they thought it to withdraw then. Then permission to file the special leave petition is granted. This was special leave from the order passed by this court on the last occasion. That's very important.
Yes, it is.
We are informed that the writ petition being WPS such and such, which is being entertained by a learned judge of the High Court at Calcutta, and various issues were flagged by the learned judge in her orders dated such and such. The matters on the file of this court as on date were kept pending only for the purpose of verifying why this was kept in the Supreme Court line, because we are being misguided. For the purpose of verifying whether the directions of this court in the state of West Bengal versus Boishaki Bhattacharya were implemented scrupulously. As a learned judge of the Calcutta High Court has now taken up that issue also, we are of the opinion that it would be appropriate that the High Court, being the court of the first instance, undertakes the exercise instead of this court. It would be open to all petitioners and applicants before this court to approach the High Court for redressal of their lawful grievance analysis in accordance with law. The High Court shall, however, ensure that none of the tainted candidates are permitted to slip through in the fresh selections, be it on any pretext. The High Court shall also ensure that the list of the tainted candidates is placed in the public domain with full details so as to ensure that this does not happen. Learned Counsel in some of the cases seek relief in terms of certain paragraphs of the decision in Boishaki Bhattacharya. They are at liberty to raise such hermeneutic exercises before the High Court. The special leave petitions are disposed of in aforesaid terms. The High Court shall examine, that's important, the matters uninfluenced by any of the observations on merits made by this court in the orders passed after the decision in Boishaki Bhattacharya. Therefore, my lord, the base now comes back to the first order of the Supreme Court in Boishaki Bhattacharya, which we have been trying to, my lord, display, your lordship. The High Court shall also be mindful of the fact that the untainted candidates in the past selection were allowed to sit for the selection test to be held afresh, and their candidature cannot be adversely affected by application of the new rules. That is the West Bengal School Service Commission Rules 2025. Pending application, if any, shall disposed of. Now, my lord, our challenge before your lordship was the vires of 2025 rules. If that is not now heard by your lordship, then all other issues will follow. Therefore, my lord, I will seek my lord's, my lord, kindly to argue on that.
Before Mr. Bhattacharya begins,
1 minute. The writ petition number that is mentioned in the
that is
order
Mousumi matter.
26288,
That is the Mousumi matter that
model.
lordships passed on.
is it there in the list?
No.
This is not in the list today. This is not in the list today.
But then it is the same lines.
Yes,
so
it is
you
the
can-
same line. There is absolutely no difference.
Yes.
Now, my lord, kindly turn to this brief that is might looking at 12434. I will refer from this.
So before Mr. Bhattacharya starts really for this big matter on merit, I have only one very preliminary based on the Supreme Court's order. Kindly have a look at these are the 7 points by the Honorable Supreme Court. What I intended to say is this.
When did the Supreme Court in which order?
This is
26th
the
of
order
November.
that was just read. Just read. Because I was trying to,
Vivek Paria. All right.
yes, I was trying to find out what are the exact, because now entirety is before your lordships. So it's a short order apparently, but it seems to me that there are fundamental 7 points are there in the order. Now, lordship may kindly have a look at the 7 points, and then I will say why I'm saying it.
What are the order is before your, my lady.
Yeah, there is a reason I'm saying.
Please take your seat.
Yes.
Do you have a chair?
My lady, I'm feeling a chair.
No, please don't. Don't sit on somebody's lap.
No, my lady,
Better?
there'll be other problems.
DAG, please sit down.
Yes.
Please sit down. Please make chairs available for the senior counsels.
I think we should, among ourselves, take a vow, because it will have an impact hugely, so that we can inhabit a congenial atmosphere one after another, so that we can make submissions. Because
You think the atmosphere is not
my lordship is controlling it, but there are lots of
Very congenial.
those are
yes.
all outwards, nothing inwards.
Now, may I just say, why did I say before Mr. Bhattacharya begins with the merit of the matter? There are 7 points. Lordship, kindly take these 7 points. Point number 1 is not important. Lordship's Mousumi's order were taken note of. Point number 2, liberty granted to approach the High Court by there are several petitioners before the Honorable Supreme Court. When I say several, there are 2 sides. One side, untainted, they got affected because they said the vacancy which was there in 2016 in some subjects, that was reduced. So that's in affectations. So even if I pass, because of that reductions, I would not be able to. And there are also, my lord, Mr. Bhattacharya's clients saying paragraph 31, therefore there is an illegality, expiry of panel, they should also go. There the Honorable Supreme Court third, no tainted candidate to slip through in the fresh selections on any pretext. So therefore, if anyone is tainted
Let the court decide who is seated and
That's I was about to say before your lordship enters
yes,
into
yes,
25.
yes. Also, possibly this was the issue
Yes, but
you
this-
submitted.
Yes,
Or you are not.
but
going
this
there to
has to be
I
heard
have
first.
this in mind.
Milord,
Let him
these are
start.
all, Milord, all. Milord,
Let him start, please.
yes, Milord, kindly come to, let us, Milord, we are concerned with the compliance of Supreme Court judgment. I shall paste that also, but kindly come to, Milord, the notification. Page 53. This is the, Milord, advertisement seeking application for new selection, press selection.
Yes.
Now, Milord, in terms of, every word is very important. 30th of May 2025. In terms of the judgment and order of the Honorable Supreme Court. Therefore, this is not an independent selection process by the School Service Commission. Order of the Supreme Court in Civil Appeal number so and so, read it in MA. I shall also place the order passed in MA. The West Bengal School Service Commission has been directed to initiate fresh selection process to the post of assistant teacher for 9-10 secondary so and so so and so. The Commission and the government of West Bengal have already applied for review of the said judgment, and order and its exercise is strictly subject to the outcome of the review. Review are dismissed. The notification is being issued for conducting second SLST for selection to the post of assistant teachers of class 9-10 in secondary, higher secondary, and to the post of assistant teacher in 11-12. So and so schools in West Bengal against the, underline this one, is very important, against the vacancies to be filled, directed to be filled up by initiating fresh selection process. And further vacancies, not this is really intrusion to the Honorable Supreme Court judgment. Further vacancies as may be received from the West Bengal Board of Secondary Education under West Bengal School Service Commission Selection Appointment Rules 2025. When the Supreme Court delivered the judgment, there was no existence of 2025 rules. Therefore, if you say that you are conducting the selection in view of the Supreme Court order, you are really diverting and violating the Supreme Court direction. That's why the Supreme Court last order said that whatever order you have passed, that is to be considered, not any subsequent observations or opinion. The entire process is being carried out strictly without prejudice to rights and contentions of the state, commission, and the board in their pending review petitions. Honorable Supreme Court Engineer so and so, the commission, I am not traveling my light with that. Then the selection process will be governed by the School Service Commission Act 1997 and subsequent amendments to Rules 2025 and the relevant NCT and state government guidelines. Then my lord will turn over, I am not troubling my lord with this. Kindly come to clause 2. Eligible candidates with minimum qualification laid down in 2025 may apply online through the official website so and so. Therefore, you are now undertaking process under the rules 2025 with the eligibility clause. This is even the initiation. And therefore, you prescribe the eligibility clause. This is important. Then, kindly, my lord, turn to next page, clause 7. Manner of selection. Selection to the post of teachers for 9, 10, 11, 12 in school shall be made, my lord, kindly underline this, on the basis of written examination, evaluation of qualifications of the candidates, oral interview, and lecture demonstration to be determined by the commission. Therefore, that area of selection is specified. I repeat, written examination, evaluation of qualifications of candidates, oral interview, and lecture demonstration. There is no scope for any other element to be incorporated, which they sought to incorporate the so-called teaching experience. If an advertisement does not make any room for that. Then preparation of panel. After evaluation of the OMR sheet, answer sheet of the written examination, the Central Commission shall prepare and publish in their website details of all candidates to be called for interview, strictly in accordance with preliminary merit score, category-wise on the basis of the rules 2025. So these are the important areas I will not point out to your lordship to show that you are inviting applications through an advertisement, giving the detail how to contest and what should be the methodology. Then kindly turn to page 56. Age limit shall be considered on the basis of age as of 1st January 2025. The age relaxation will be given to the candidates who have been given the benefit of age relaxation as per order dated 3rd April 25 of the Honorable Supreme Court. Provided further that a person who comes under more than one category shall be eligible for only one benefit of relaxation, which shall be considered most beneficial to him. Then next page note. Qualifications obtained on or before the last date of receiving online application mentioned in the application form shall only be counted for academic and professional qualification. Then the tentative schedule. Now, this is the advertisement. And this advertisement will not seems to be in accordance with the constitutional principle of Article 14 and 16. You invite all. Now kindly turn to rule at page 39. Now, this is not without prejudicing my fundamental point that you have started this selection process in terms of the Supreme Court order, you say, and Supreme Court order which was passed, there was no 2025 rules. Though it's not recorded, latest observation of the judges are very clear. And that's why I say that only the final order should be considered, not the subsequent any opinion or orders. Here, Lordship, kindly come to Milord. This 29th of May 2025 is the publication of rules, and the publication of advertisement was on the 30th May. Well, just please notice. Kindly turn to page 40, the interview list. Interview list in respect of SLST means in case of vacancies in the post. In respect of means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit for oral interview and lecture demonstration category-wise on the basis of the preliminary merit score. That is score from written test and TET and academic score in the ratio of 1.6:1. Now, this has been reflected in the advertisement. Then, merit list in respect of SLST means in case of post, a list of candidates prepared category-wise on the basis of merit, which shall mean in addition to what has been stated in Rule T121K, marks obtained in oral interview, lecture demonstration, prior teaching experience. This is the incorporation by which our allegation, we are freshers, by which you wanted to give credit to the appointments which were set at naught, declaring void by the Constitutional Court. This is without malice in law. You had never declared in the advertisement that there will be scope of any prior teaching experience. Now you incorporate this. Now kindly come to again, my lord, the rules in the schedule. Now, kindly, before that, Lordship may turn to page 42. Rule 7, information regarding vacancies. The Commissioner of School Education shall, on being intimated by the West Bengal Board of Secondary Education, as and when deemed appropriate by the board, prepare a vacancy statement of assistant teachers, and with the approval of the state government, send same to the board. The board shall, with prior approval of state government, send a category-wise vacancy report. Now, the first question, if the rule is promulgated on 29th of May, advertisement is made on 30th of May, when did the board undertook this exercise to identify the vacancies? But it is humanly impossible that you could identify the so-called extra vacancies.
Yes.
Then the report, as mentioned above, shall be sent to the Central Commission in the following manner. Firstly, before the date of publication of the advertisement inviting application, there shall be termed as indicative vacancy. And finally, before the date of publication of the interview list, there shall be termed as final vacancy, which may increase or decrease in comparison to the indicative vacancy. Therefore, the indicative vacancy, my lord, is the vacancy which would be arrived at after exercise of Rule 7, and that will be intimated. Lord, Lordship will definitely ask for production of the records to show. When did the exercise under Rule 7 was undertaken by the board to intimate the vacancies, which prompted the authorities to advertise very next day, 30th. Now, these are all stage managed, therefore I say. Now, kindly come to, my lord, the rules schedule.
He's going to continue. He's going to continue.
At page 49. Selection to the post of assistant teacher 9 so and so. Now, I just take your lordship to the relevant portions. Written examination OMR based 60 marks, but which is in variance with the 2016 rules. I shall paste that also. Educational qualification 10 marks. Here also, my lord, will be pleased to note, I will demonstrate that the assessment nature has been varied from 2016 rules. Based on marks of graduation, post-graduation, the subject for which applied up to this, my lord, level playing field. Then, prior teaching experience 10 marks. At the secondary level in a government or government aided or a government sponsored school, calculated on the basis of 2 marks for each year of service in substantive post as permanent or on contractual basis. Oral interview 10 marks, lecture demonstration 10 marks. Now, apart from this prior teaching experience, all other things, Lord, I would say, of the level playing field. All have the same benefit. This prior teaching experience is a new incorporation to ensure that these candidates, I do not give any adjective, whose appointments were cancelled, declaring void. Not some irregularities, therefore I cancel it, it's void. They have to be given the benefit, that is the reflection here. Now, my lord will kindly take to 2016 rules. Because they say that this is because of the Supreme Court judgment. Now, 2016 rules is 346. Kindly will not count to page 348. The qualification that it really in fact starts from 347.
Only the freshers.
Name of post qualification and age.
Yes.
The appointment of persons to the post mentioned in column 2 of schedule 1 shall be made by selection, that is direct recruitment. This has also some bearing of service jurisprudence. They meant to say this is not a promotional post. Direct recruitment, therefore, everybody will enter through the same channel, having same competitive qualification. Name of post runs so that provided that the qualification of teacher includes academic qualification and professional qualification of teachers for 9-10 as notified by NCTE from time to time applicable on the date of advertisement. Provided further that the certificates obtained on or before the last date of receipt applications mentioned, application shall be counted for academic and professional qualification. Well, I am not troubling with the age limit.
347.
So for the proviso is there for the teaching and non-teaching staff, then kindly come to that additional essential qualification of candidate. A candidate willing to be selected as teacher for class 9 and 10 of any school having Bengali or English, and so well, they have to have the language preference. A manner of selection. Selection to the post of teacher of 9-10 shall be made on the basis of the results of the state level test, comprising written examination conducted by the Central Commission, evaluation of academic and professional qualification, and personality test of the candidate in the manner specified. But there was no scope for any professional qualification. And also kindly come to the schedule of these rules. At page 352. Select the part A, the others are not disputed. Selection to the post of teachers for 9-10 in school shall be made on the basis of written examination, evaluation of qualifications of the candidates, and personality test to be determined by the commission in the following manner. Written examination, academic qualification, personality test. No professional experience. Sorry, the prior teaching experience. Then the part B, but similar. I am not just troubling my lord with these similar things. Well, different qualification, 9-10, like that. And part B is also important. Here, my lord, how the best persons would be chosen for teachers category, there is a rationale, part B. Provision relating to evaluation of academic qualifications. It starts from school final Madhyamik. Full marks 10. If you have 60% above, how the marks would be distributed. For the higher secondary stage, then Milord, graduate stage, postgraduate stage. Therefore, your entire career is being assessed for selecting the best out of the lot. With 25 rules, Milord, this has gone. Just turn to page 49, my lord, you'll find here, this assessment of continuous academic career gone. Page 49. Yes. Schedule 2. I had placed written examination 55, it was modified anyway, but then how the educational excellence should be assessed based on marks of graduation or post-graduation, or not and. The other career, whether you had just passed through Madhyamik, somehow has secondary, which you had taken note of harassment, now is removed. Only graduation and post-graduation. The intention of making these rules is to again give a leeway to those persons whose appointments are cancelled. Why? Now, these are the rules on 25. Now, I will trouble your shift to come to the Supreme Court judgment. Because the Honorable Supreme Court says you have to strictly go by the judgment which you had delivered. That judgment starts at page 60. Go there, 60. But excuse me, Miller, I would take the trouble to read the judgment in its entirety, if your lordship permits me. The impugned judgment, that is the High Court judgment, Division Bench judgment, at page 60, dated 22nd April 24, en bloc, set aside the 2016 selection process conducted by the School Service Commission, so and so. The appellants before us are the selectees, some of whom have been working over 5 years. They fall into two categories: selectees with purported evidence and material including wrongdoing, other selectees who claim that they were validly selected and have committed no wrongdoing. State also challenged. Now kindly come to the relevant portion. Para 20, illegalities in the selection process. At page 77. In our opinion, this is a case wherein the entire selection process has been vitiated and tainted beyond resolution. Entire. Manipulations and frauds on a large scale, coupled with attempted cover-up, have dented the selection process beyond repair and partial redemption. The credibility and legitimacy of the selections are denuded. High Court has referred the illegalities. I am not troubling my lord, but the Supreme Court's opinion is at the very beginning of this 8th paragraph. Then kindly will come to the directions. Kindly turn to page 90, the conclusions. The last question relates to the relief. Whether it requires any modification, we find no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates were appointed must be terminated, and they should be required to refund any salary payment received. Since their appointments were the result of fraud, this amounts to cheating. Therefore, we see no justification to alter this direction. Till date, my lord, the tainted list has not come out. The tainted categories have been defined by the High Court, upheld by the Supreme Court. That I shall place later. For candidates not specifically found to be tainted, their entire selection process has been rightly declared null and void due to the egregious violations of the illegalities which violates Article 1416. Null and void. No person of that category can claim that I have an experience. As such, the appointments of these candidates are cancelled. However, candidates who are already employed need not be asked to refund or restitute any payments to them. Their services will be terminated No candidates can be appointed once the entire examination process results have been declared void. No candidates can be appointed. This is the Supreme Court's clear verdict. Then next, some of the candidates, appointed candidates, who do not fall within the category of tainted candidates may have previously worked. May I give a little background of this? Some appears says that we were properly appointed, we were working in different institutions, maybe primary teacher. But we thought we'll have a better opportunity. Since this recruitment goes, kindly restore that old recruitment where we are not tainted. And that appointment is never questioned. The Honorable Supreme Court, my lord, out of his grace, gives this direction. I mean, read it. Some of the appointed candidates who worked in different departments of the state government or with autonomous bodies. In such cases, although their appointments are cancelled, these candidates will have the right to apply to their previous departments or autonomous bodies to continue in service with those entities. Nothing to do with this teacher's profession here. These applications must be processed by the respective departments within 3 months, and the candidates will be allowed to resume their position. Further, the period between the termination of their previous appointment, their joining will not be considered a break in service. Their seniority, other entitlements will be preserved and they will be eligible for increment, so and so. Therefore, this is completely a separate category. Few who had earlier had a regular appointment, this will because very well go back. Then lastly, we address the case of disabled candidates. Our attention has been drawn to one such case where the impugned judgment had held the appointee, Ms. Soma Das, shall be allowed to continue on humanitarian grounds. While we will not interfere with this finding, Soma is made an exception. We make it clear that other differently able candidates will not be entitled to the same benefit, as it would contradict legal principles and the rule of law. However, in consideration of the disability, these candidates will be permitted to continue and receive wages until the fresh selection process and appointments are completed. Again, a special category. Very well, you continue till fresh. The disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process if required, with age relaxation and other concessions. Similarly, other candidates who are not specifically tainted will also be eligible to participate. Therefore, my lord, the disabled who are not specifically tainted, they will be allowed to participate. This logic on the last occasion, the Supreme Court accepted. Supreme Court said, read it similarly. Not that tainted disabled would be allowed to participate. Our observational findings will not influence the criminal proceedings. Accordingly, we afford the impugned judgment cancelling en bloc entire selection process, but have made certain modifications in directions issued by High Court. The appeals are disposed of. Now, after this, government Miller takes out a miscellaneous application. No, application the kotha hai. Well, I'm just placed the application also. I have to cross title it. I just play, yes. Anyway, I'm not. Let us come to the order on their application, page 107. We are, got it. We are inclined to accept the prayer in the present application insofar as it relates to assistant teachers for class 9, 10 and class 11, 12, not found to be tainted, subject to the following conditions. An advertisement for fresh recruitment to the aforesaid posts shall be published before 31st of May 25. This is on the application of the state, the board. They made an application, though the copy of the application will place your lordship, that the school's running would be difficult. Please allow some of the teachers to continue to see that the education is not affected. Honorable Supreme Court said very well, only for the so-called untainted candidates till 31st December. In the meantime, start a recruitment process of the aforesaid post. And not that application of board is at page 249. Yes, this is also important to place. At page 251, the instant application is being filed by the applicant seeking issuance of appropriate direction from this court pursuant to the final judgment and order dated 3rd April 2025. Therefore, they accepted that the judgment has reached its finality. If the appellant is an independent statutory body, so and so, I am not telling that. Then paragraph 3, the appellant had challenged the final judgment and order dated 22nd April passed by the Calcutta High Court. It was dismissed. Then they go to the directions of the Honorable Supreme Court. Then kindly come to paragraph 6. By way of the instant application, got it?
Yes.
By way of the instant application, the appellant most humbly craves to seek appropriate directions or modifications of the judgment to permit the appointed candidates not found to be tainted, their own admission, to temporarily continue in various schools without claiming any equity in their favor until the end of academic year or until the process for fresh appointment is concluded. Therefore, fresh appointment is pursuant to the direction passed by the Supreme Court 30th April. Supreme Court fill up these posts. Therefore, they admit this. And on such application, their prayer was that the prayer was at page 260. Their MA application. The permit the appointees not found to be tainted to continue in service till the end of the academic year until the process of fresh appointments to such post is concluded, whichever is earlier. On that, the Honorable Supreme Court passed this order at page 107. It's very important. An advertisement for fresh recruitment shall be published before 31st May because they say that we want to carry on the fresh recruitment process. The examination and the entire recruitment process shall be completed by 31st December 2025. Now, kindly will not take note of the direction of the Supreme Court that advertisement should be published by 31st of May for the posts which were found to be illegally appointed by the Supreme Court. On 31st of May, they issue 30th May, they issued the advertisement. 29th May, they issue notification for fresh rules. I would again say, the entire chain of action reflects the malice in law. Then the state governments, this is very important. Supreme Court was so skeptic about their behavior. The state government, the applicant, that is board, and the School Service Commission shall file, nobody could subsequently escape saying that I did not do it, shall file their respective affidavits by 31st of May, enclosing therewith a copy of the advertisement for the fresh recruitment as well as the schedule therefore, so as to ensure completion of the recruitment process by 31st December. In case the advertisement is not published, the affidavits are not filed, the appropriate orders will be passed by this court, including imposition of post and vacating of the order. In fear of this, it was done on 30th. Then this is important. We clarify that these orders shall not be read as conferring any special right or advantage on the aforesaid teachers, in so far as the fresh recruitment process is concerned. Therefore, without this continuation, even for a limited period, they cannot take any advantage there because the entire thing was void. Supreme Court was very much not conscious of this prayer. Then we are not inclined to accept the prayer In the present application, insofar as non-teaching post group CG are concerned, as the number of appointees specifically found to be tainted in this age group is substantively high. And secondly, what was prompted to us to pass this order in respect of assistant teachers not found to be tainted is that the students undergoing study presently should not suffer on account of the lack of teachers. Now, your lordship has been pleased now to take note of this judgment, and Supreme Court says any observation you have made after our final order should not be taken note of. Here, my lord, the final order says everything is void, and then on their place says you allow them to continue for those posts without conferring any benefit to them. In this background, 25 rules I have placed, my lord, that the purpose was to, my lord, confer them the extra benefit, which is in total disregard to the Supreme Court judgment. And that's why the Supreme Court very categorically, if I may again take back to your lordship, says, since my lord's various orders were noted, these were flagged. The third page, the High Court shall examine the matters in uninfluenced by any of the observations on merits made by this court in the orders passed after the decision in Boishati Bhattacharya Supra. Therefore, the decision is conclusive. You cannot go beyond that. Now, my lord, these rules, according to my submission, my lord, is ultra vires to Article 14 and 16.
You are appearing for the freshers.
I am appearing for the freshers. And Lord, the advertisement invited. We are invited that this is the process of selection would be done. Now we find in the rules you have made such a provision which makes us almost impossible to contest. No level playing field. In that background, this virus of the rule is challenged. And if your lordship is with us, then, my lord, one chapter is closed. They have to do afresh. And if your lordship do not agree that this rule is not ultra vires, then my submission is that even the application of rules is made in such a manner to give illegal benefit in violation of that rules. These are the 2 points. Now, my lord, so far the virus of the rules is concerned, my lord, may I just take your lordship, my lord, to the authorities. রাখো আমি এক এক করে দেখাই ছটফট না করে জিজ্ঞেস করো না তুমি অনেক I take your lordship Millard's statement to the latest judgment of the Supreme Court in Assam versus Rava 2025 volume 7 SCC 705. The judgment is delivered by Justice Dipankar Dutt. এখানে আরে এটা তো অন্যটা 25/7 SCC দেখো আছে
এই তিনটে 18 নম্বর সিরিয়াল নাম্বার 18
আমার বই দাও না আমার বইটা কোথায়
সিরিয়াল নাম্বার
What are all these? These are judgments.
জাজমেন্ট কম্পাইলেশন সিরিয়াল নাম্বার 18
Serial number 8.
18 18
পরে হবে নিশ্চয়ই।
529 to 550 reported
529 to 552.
জাজমেন্টে এই একটা কম্পাইলেশন দিয়ে দাও না ইন্দাকে
Give the first pages only, the references. You are not required to give the
this is
recipe of judgments.
State of Assam versus Aravind Rava 2025-7 Supreme Court cases page 705.
ইন্ডেক্সটা দিলেও তো জি কথা ইন্ডেক্সটা দিয়ে দিলেও আমরা ফলো করতে পারবো ইন্ডেক্সটা
দিল।
একটা দিয়ে দিচ্ছি।
Now, my lord, the relevant paragraphs would be, kindly will not turn to paragraph 39. That the issue was whether in absence of statutory rules, by administrative order, appointments could be done. The Supreme Court was considering, yes. দর্শক পেজটা বলে দাও না তো
39.
paragraph 39.
Yes, paragraph 39.
It cannot be gainsaid that the factors of when, which, what, who, and how that are associated with the recruitment or selection process is the prerogative of the recruiting authority and the selectors. However, at the same time, the process has to be conducted consistent with the statutory provisions governing the same, if any, as well as principles of absolute fairness and complete non-arbitrariness. Though it is true that law does not postulate a fetter on the authority of the employer, state, and is within the domain of the government when to initiate a process of recruitment for public employment, either according to recruitment rules or even in absence thereof, it is for the government of the day to decide in which manner it proposes to conduct selection, what would be the various stages the candidate aspiring for appointment have to pass through in order to be placed in the select list, who would be selectors, and how weightage is to be given to each of the testing methods. A great deal of credence is lent to a process if it is fairly and transparently conducted in accordance with rules. Whatever be its source, without the slightest hint of any bias or favoritism or nepotism. Normally, it is not for the courts to interfere unless the process smacks of malafidis, that I have already tried to develop this point. However, the right to be considered for public employment being a fundamental right, it would be safe and prudent to have a recruitment rules to govern the process of selection so that the best possible talent is appointed in public service. Obviously, assessing the merit of the candidate aspiring for public employment on the basis of a prescribed standard would not only provide a level playing field for each of them, the excellence of an institution to which the appointment is made would depend directly on the proficiency of its number staff, and that would in turn depend on the quality and merit of those who offer themselves for selections and ultimately get selected, necessitating the selection to be conducted within a hidden taint or masked malafidis. Last but not the least, having regard to present times when corruption has been held to be a walk of life by certain responsible citizens of the country, it would have been desirable if the process of recruitment of 104 constables were conducted after framing recruitment rules and also prescribing a written examination to keep the process absolutely above board. What is the principle is there must be a level playing field. And you have destroyed the level playing field with a malafide intention. I have said, Lord, the malafide intention is not at all personal malafide, but malice in law is also malafide. This is the latest judgment, and another judgment will not to show whether any preference can be given at the time of initial recruitment, 1995 supplementary to SSC.
Entry 70.
না না আমি আমার বই থেকে বলবো
95 supplementary to SSC.
page 235.
Entry 70.
এটা কই বই
রাহুল
টু দাও
রাহুলকে পাঠিয়েছো রাহুল পাঠিয়ে দিই এই শিক্ষণ একটু দিয়ে
এই জজকে রেফারেন্স তো দাও
We'll all learn more law.
आगे जॉर्ज साहब के दाओ वो दे पढ़ देंगे
Gives us opportunity to learn the subject.
Now, this is a three judges bench order 1995 supplementary to SCC.
Got it. Thank you, madam.
Has got it.
Yes.
Kindly turn to me, Lord, paragraph stated paragraph 13. Let me start from paragraph 11. We shall now briefly refer to the main grievances voiced by the learned counsel for the respective parties in connection with these two GOs. It was submitted by learned counsel appearing for non-Telugu speaking candidates that when a direct recruitment is appointed to any public service, maybe in the lower echelon of service, like Group T and Group 4 posts, which may consist of clerical posts, merit should be the criteria which the Public Service Commission should follow. If a candidate satisfied the basic requirement of eligibility for competing in such public recruitment, provision of such weightage of 5% of marks to Telugu medium candidates would only per se be arbitrary and discriminatory, and would be destructive of the concept of selection on pure merits. That even if Telugu be the official language as adopted by the state in the light of linguistic policy, once a candidate is recruited from the open market as per the relevant rules, before he is confirmed in service and before he is entitled to earn an increment in service, he is required to pass the Telugu language examination. This completely meets the requirement of the department that the candidate must be having working knowledge of Telugu to enable him to converse and correspond in Telugu with members of the public as well as the other government departments. This satisfies the object of securing efficiency administration. To put a further fetter at the entry point, now this is vital, by giving a special weightage of 5% marks on the aggregate to candidates who have passed their graduation examination Telugu medium would therefore have no real nexus to the object sought to be achieved and would be counterproductive, as more meritorious students, even though having secured more marks in the aggregate in the competitive test, would be elbowed out by those standing far behind in the queue only on the specious plea that they have passed the qualifying examination Telugu medium. But here the fact is so glaring. The fresh candidates even secured 100% marks on merit were out of competition because of 10 marks. That even these candidates who have passed qualifying graduate examination in English medium or any other medium in the state have to appear compulsorily in one of the paper of Telugu language. Therefore, he is also having sufficient working knowledge of Telugu to enable him to correspond in Telugu as required by the exigency of service. That when under the relevant recruitment rules for the post concerned, the minimum educational qualification prescribed is passing of graduation in any subject, the further question whether he has passed this examination in Telugu medium or English medium would be totally irrelevant. That if a candidate who has passed graduation examination in English medium cannot be told of the gets and can legally compete in the examination for recruitment to the public post advertised by the Public Service Commission, such imposition of 5% weightage of total marks in favor of candidates who had passed qualifying examination of graduation in Telugu medium would amount to imposing an additional qualification or eligibility criteria which is dehors the recruitment rules and would result in total arbitrariness and would amount to give a discriminatory and hostile treatment to all candidates who otherwise are qualified to contest but did not have Telugu medium at their graduation level. If I may put my facts here, the language would be that the persons who are otherwise qualified to contest but did not have teaching experience will be out of consideration. It was also submitted that the object about maintaining the efficiency of the administration can also be achieved by providing or prescribing for one more paper in the competitive test on Telugu language itself, as in that eventuality all the candidates competing for examination will have an equal chance to compete for the said examination and show their proficiency in the subjects concerned in which they are examined. For all these reasons, it was submitted that the decision of the tribunal is quite correct, and similarly, the decision rendered by a single judge of the High Court, as he then was, is equally correct, and the division bench judgment which upturned it deserved to be set aside. Now, the relevant paragraph 13, I have given the factual background of that. We have given our anxious consideration to these rival contentions and have reached the conclusion that the impugned government orders and the consequential statutory rules framed under Article 309 proviso do not stand the test of Article 14 and 16 of the Constitution and will have to be declared invalid. The reasons for our aforesaid conclusions may now be catalogued as under. 1. It has to be kept in view that recruitment to public service through the Public Service Commission is the open recruitment where any eligible candidate is permitted to compete on a par with other competitors. The minimum eligibility criteria for recruitment to such post is graduation. Therefore, it does not mean that candidates who have passed their graduation in non-Telugu medium cannot compete for the said post. It has to be noted that the minimum educational qualification for appearing at the selection is graduation simpliciter. But kindly just go back to the advertisement, minimum eligibility criteria. If the object or underlying the impugned provision of weightage of marks on the aggregate to candidates who have passed their graduation in Telugu is to permit candidates knowing Telugu language to occupy the post concerned, then it cannot be said that merely because a person has passed his graduation in Telugu medium, he alone will be proficient in Telugu and not the candidate who has passed his graduation in any other language. For appointing persons to post in public services through direct recruitment, the criteria has to be pure merit. Therefore, all candidates who possess minimum educational qualification have to be assessed on the basis of their relative merits. At that stage of assessment, if 5% more marks in the aggregate are added in the assessment of candidates who have passed minimum educational qualification through Telugu medium, the very criteria of relative merits would get frustrated and would become assured. In this connection, we may usefully refer the decision of this court in case of Pradeep Jain versus of India, but I am not really reading the quotation from the other judgment. Then we'll kindly skip over, come to this paragraph. It is of course true that aforesaid observations are made in connection with the admission in MBBS and postgraduate course. And in the light of the question whether discrimination on the ground of place of birth would be countenanced under Article 15(1) and 2. However, the sweep of Article 14, read with Article 16(1), is no less pervasive. Article 16(1) ensures equality of opportunity for all citizens in the matter of employment or appointment to any office under the state. Article 14 declares that the state shall not deny to any person equality before the law or the equal protection of laws within the territory of India. The principles emerging from Article 14 and 16 are well settled. The object is to ensure equality to all those who are similarly situated. In other words, all the citizens applying for employment under the state are entitled to be treated alike. If that is so, it is difficult to appreciate how, having once allowed all candidates having minimum qualification of graduation in any medium to compete for the post, a further special beneficial treatment can be given to only candidates passing minimum educational qualification examination, namely graduation in Telugu medium, after their relative merits are assessed vis-a-vis other candidates in open competition. The similar is the provision here. After all things, then you get 10 marks. Reliance placed by learned advocates for the state of Andhra Pradesh and Telugu medium candidates on the decision of this court in the case of Sanjay Halwat is of no assistance, as on the peculiar facts of that case, the court held that weightage of 10 extra marks to the candidates who have graduated from medical college at Rohtak was not discriminatory or violative of Article 14. In that case, extra marks were found to be justified being awarded to local medical graduates for the purpose of ensuring that the medical facility in the state is not impaired in any way because of dearth of doctors. In order to attract residents of Haryana to postgraduate courses after they obtain medical degrees, this weightage of 10 marks was found necessary and reasonable. That was to ensure for the people of the state services of good doctors hailing from Haryana itself. It was also found that this weightage was based on domicile in Haryana or education at the Medical College Haryana. This does not have the effect of shutting the doors of admission to the outstation boys. The aforesaid weightage of 10 marks was therefore justified on the peculiar facts of that case before the court. Such is not the situation in the present case. The aforesaid subclassification on meritorious candidates into Telugu medium candidates and non-Telugu medium candidates, insofar as the graduation is concerned, does not have any rational nexus to the object sought to be achieved thereby. If the object is to have a proficiency in Telugu language, which is the official language of the state, it has to be kept in view that even those candidates who have studied in non-Telugu medium like English or Hindi at graduation level also have to pass one compulsory paper of Telugu. It may be pointed out that the state had adopted, after passing the Official Language Act 66, three-language formula in the field of education. The students studying in other media are also required to pass a paper in Telugu language. Therefore, they have got working knowledge of Telugu. It has also to be kept in view that even after they are appointed to the post for which they compete, they have to clear the language examination before getting increment or even confirmation. And if they do not clear the examination, they are liable to be discharged. If that is so, proficiency in Telugu language at entry point pales into insignificance. So far as the recruitment to this post are concerned, it may be that the selected candidates concerned lower echelon of service may have to deal with public in Telugu or may have to correspond with other public departments or authorities in Telugu language, but that is well ensured by the requiring of passing Telugu language examination after being recruited to the post. Under these circumstances, giving a further weightage of 35 or 40 marks to such candidates even prior to their entry in service has really no nexus to the object sought to be achieved by such provision. It cannot be said that merely because a person has passed his graduation in Telugu medium, he alone is proficient in Telugu and not the candidates who has passed his graduation in other language. There may be cases that I am not just troubling my lord reading the entire thing, then kindly come to the conclusive decisions. For all these reasons, it must be held that the present rule of weightage to be given to a candidate who has passed graduation in Telugu is violative of Article 14 and 16 of the Constitution and does not represent any valid and reasonable classification having a rational nexus to the objects sought to be achieved. Now, with another judgment, my lord, this is a three judges bench again. 2005, volume 13 SCC. It is what?
This one is not in.
What about index নেই?
না ওটা পরে দেয়া আছে index
পরে
কত?
2005 13 SCC 721 2005 13 SCC 2005 13 SCC 721 720
paragraph 11. Taking our findings as made herein earlier to the extent that the writ petitioner was entitled to sit and write the examination for selection of probationary officer in the bank, let us now proceed to consider whether the writ petitioner would be entitled to appointment in the post of probationary officer if successful in the written examination in view of the nature of the job to be performed as probationary officer. Before we deal with this aspect of the matter, we may take into consideration yet another aspect of the matter, namely, whether denial of permission to the writ petitioner to sit and write the examination for the post of probationary officer in the bank offence Article 14 and 16 of the Constitution. Article 14 of the Constitution guarantees to every citizen of India the right to equality before the law or the equal protection of law. The first expression, equality before the law, which is taken from the English common law, is a declaration of equality of all persons within the territory of India, implying thereby the absence of any special privilege in favor of any individual. It also means that amongst the equals, the law should be equal and should be equally administered, and the like should be treated alike. Now, here all are at the entry point of teaching job. Similar. Then how can you give additional benefit of earlier teaching experience, which under the law you cannot give? Because there was no experience, the appointments being void. That what it forbids discrimination between persons who are substantially in similar circumstances or conditions. Yes. When in similar circumstances, you have to sit for the exam for job. It does not forbid different treatment of unequals. Article 14 of the Constitution is both negative and positive Right, negative in the sense that no one can be discriminated against anybody and everyone should be treated as equals. The latter is the core and essence of the right to equality, and the state has the obligation to take necessary steps so that every individual is given equal respect and concern which is entitled to as a human being. Therefore, Article 14 contemplates reasonableness in state action, the absence of which would entail the violation of Article 14. Now, the paragraph 12 is also details discussion is made. I am not reading the entire thing. I would just only appeal to your lordship that kindly come to the 15 lines from the bottom. Under Article 16 of the Constitution, the general rule laid down is that there should be equal opportunity for citizens in matters relating to employment or appointment to any office under the state. The expression matter relating to employment and appointment includes all matters in relation to employment, both prior and subsequent to the employments. That I place this to show that what really Article 16 intends to carry forward for the principle of equality. Therefore, the Article 16 of the Constitution, what is guaranteed is equal opportunity to all persons. This qualification for recruitment to government service, and it is open to the authority to lay down such other conditions of appointment as would be conducive to the maintenance of proper discipline among government service. Like other employers, the government is also entitled to pick and choose from amongst a large number of candidates offering themselves for employment. But this can only be done in one condition, that all applicants must be given equal opportunity along with others who qualify for the same post. Well, I stop here. This is the basic principle. You are going for a public appointment. Teachers, they are not like any other job or profession. The teachers, they really create the nation. If at the end point of time they feel that we are out because we are not having some other qualifications, and what would the students feel? Nowadays, everything is transparent. Now I find some teachers are crying that our students are not respecting us. Why would they respect? If they find that teachers have got appointment through illegal means. And Article 1416 has to be complied with strictly. And particularly in this case, I would repeat, the direction of Supreme Court was only to fill up those posts which fell vacant because of the judgment of the Supreme Court. And he wanted to amalgamate that. Now, this being the position, Milord, so far the key. Now, Milord, the question would come, I'm sure, that another writ petitioner, not this client, though I was the counsel, that's a different thing. Counsel doesn't have any cause. There, Milord, this writ petition was moved. Let us see what was the issue and how the court dealt with that. Division bench judgment. First of all, the principle is that I am not bound by that judge, with the best of respect. Definitely, they can not cite it as a matter of precedence. But the precedent depends on whether the points are good and decided. Now, this is settled law that even little bit of variation of facts, even one word, would completely change the ratio. Now, kindly take Rashakada. This judgment of Orunima Pal. Rashakada. Yecho? আগের দিন দেওয়া ছিল বললে আমি নাকি আর্গুমেন্ট সময় আমার কপি দাও কাইন্ডলি সবগুলো একসাথে করা আছে page number 24. Internal page. Now, kindly come to me, Lord, page 2. The present appeal is directed against a portion of the impugned order, whereby the contention of the appellant that the recruitment process initiated in 2025 on the basis of the shared rules of 2025 could not be made applicable to the present appellants as they are to be considered under the recruitment rules of 2016 was rejected by reasoned order. So this was the issue. While considering this issue, the Honorable Court categorically records that since the rules are not under challenge.
Page number 24, internal page 24.
Will kindly turn to page 24, the paragraph 34 of the judgment.
Second series of matters that we are working on. Go matter.
That's very interesting argument. Kindly turn to paragraph 34. The awarding of 10 marks.
Yes.
Awarding of 10 marks is an weightage to be given on the basis of experience that is only expected that in selection process of this nature of kind, all the candidates are required to undergo the rigorous selection process. Now, how the deepest of respect, court will not contradict itself. In order to select the most suitable candidates, proportionate weightage based on the length of experience to the extent of 10 marks given to such candidates. So the first page says it should be considered contested by all candidates rigorous. And then section 10 marks weightage to given to such candidates. The object is to select and appoint an experienced teacher. That was not the advertisement. As rightly pointed out, learned Advocate General and also Mr. Bandyopadhyay, appearing for the commission, that the writ petitioners are not coming within the purview of the categories in whose favor benefits and concessions have been extended. The judgment of the Supreme Court, they are not extended in paragraph 49 of the judgment of the Supreme Court. They are not candidates selected in 2016 recruitment process. In the meantime, they have not also applied for service in any educational institution. It shall be the duty and responsibility of state to ensure quality of education, and the eligibility criteria should be framed keeping in mind the interest of students. But eligibility criteria did not mention, even in the advertisement of the rules, that 10 marks should be given. If we accept the submission of so-and-so, then for the selection of the same subject teacher to different eligibility has to be applied. But the deepest respect, this is just the other way. The eligibility criteria in the selection process 2016 is different from recruitment process 2025. Rules are more stringent and student-centric. The division in the eligibility criteria is in accordance with the consonance with the NCT guidelines, where I fail to understand NCT fixes some eligibility, minimum eligibility, nothing else. Anyway, therefore, here after considering all this, now the court says, when understood that this might lead to an incongruity, the court says next page. The recruitment rules of 2025 has not been challenged by any of the appellants. Now I have challenged this. I mean, this petition has challenged this. Therefore, this judgment of division bench that will have no application even by the precedents in any way. Therefore, this judgment will not cannot stand in the way, and particularly after the last order of the Supreme Court, where the Supreme Court has made it very categorically that only the final judgment has to be considered. And final judgment says these are all void. And even on their modification application, Supreme Court says no benefit should be accrued to them. Therefore, if the 10 marks was open for all, then at the eligibility criteria, it would have been said that you must have teaching experience. So that the other experienced people could have applied. But here also, the well-settled judgment of the air India transport comes. Whatever you declare, There was issue second grade hoteliers and third grade were given, but he did not notify this. It becomes bad. But in this background, I sure the rules is ultra vires and should be declared bad. And secondly, if not your lordship, that is in item 25. But if your lordship is not with me, then what would be the interpretation of rules? Kindly come to Milord page 39 the rules.
25 টা দিচ্ছি।
দাও যশোরকে আমাকে দিতে হবে না।
25 মানে নাম কি?
You are referring to the rules?
Yes, yes.
It is here.
হ্যাঁ,
So we can look at it.
এই চলে যান না আপনি
Rules.
পরের দিন বলতে পারবেন।
26, 25.
25 rules.
39 page 39
হ্যাঁ,
এটার পেজ
বলুন না।
39
It should be shown.
হুম।
And then be followed by other advocates. May I have my lord answer?
ওটা ওই আসবো দেখাবো সব।
Personal ground.
All right, all right.
I have to leave the court.
All right.
Thank you. Yes. I'll come back on Monday.
Yes.
আজকে শেষ হবে না।
এটা কি হয়েছে বলেছে ওই ইয়েতে নেওয়া হ্যাঁ হ্যাঁ ঠিক আছে 25
হ্যাঁ তাই তো দেখো অর্গানো বার করো। হুম। এই ইস্যুটাই তো তাহলে আবার কি দেখাবার কি আছে? Now, my lord's order was specifically referred by the Honorable Supreme Court. Lordship is well aware. I need not really trouble my lord with that. Therefore, the issues which are to be discussed are reflected and flagged in 7th November, 11th November, and 12th November, 19th November. I am really within the issues which was flagged by your lordship. Now, kindly come to me, lord, the rule against. Without prejudice to the argument by the other petitioner that this is ultra vires. Now, if, my lord, some of the petitioners feel that if ultimately the rule is upheld, then what would be the
these set of petitioners are also freshers?
Yes, 25 and 44. 44. Item number 44.
I'll come to the item. I am at the rule now.
Yes. Now, will kindly come to me, lord.
2K and 12
of 25 rules.
Rule 2K.
সেটা কি এখানে ছিল না?
Interview list. In respect of SLST means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit. But every word, not the statute makers do not waste any word. That's the principle. To be called on merit for oral interview and lecture demonstration. Category wise on the basis of preliminary merit. Therefore, you have to first fix up the preliminary merit, then invite them for interview and lecture demonstration. And what are the preliminary score? That is score from written test. The test for upper primary and traveling and academic score in the ratio of students. What is academic score? That is defined in, that is indicated in the advertisement. These are the eligibility clause academic score. Then after you prepare the preliminary merit, you call for the interview. Then final merit list. In respect of the SLST, a list of candidates prepared category-wise on the basis of merit, which will mean in addition. It's very categorical. Whether the addition comes at this stage to what has been stated in the rule 21K. Marks obtained in oral interview, lecture demonstration, and prior teaching experience. Therefore, prior teaching experience, if at all, stand. The scrutiny of Article 1416 can only be considered after the preliminary screening is over, not before that. This is at the final merit stage. What they are doing, they are giving additional 10 marks to hoodwink the meritorious people at the preliminary stage. Though rule does not permit so. This is my very categorical submission, and kindly also come to, my lord, the schedule. My lord, again, I would say, my lord, the statute makers, my lord, do not waste any word. Schedule 2, written examination, Weimar, then academics. Where in the parent rule, they say, my lord, academic. And why these academics? When you bring prior teacher experience, this is not really declared academic qualification. And you make it academics, even assuming this is part of academics, but this would not come when you are preparing the interview list. Therefore, 10 marks cannot be given, if at all can be given only at this stage of preparation of final merit list, to give them the handicap. That in our school days, someone was little weak, he was given a handicap for a flat race. Then you are given 10 marks of handicap when you are really suffering. At what stage? At the final stage, provided you come across on your merit from preliminary test, which many of them could not. And yes, another word is very important, that is score. Merit score, academic score. Academic score, how it is asset? The educational qualification, 10 marks. And by percentage, you will get, if 60% above 10 marks, their merit score is mentioned. Below 60%, 8 marks. Below 50%, 6 marks. And what is the scope for scoring in teaching experience? The court is invited to give a harmonious construction and reasonable meaning. But unfortunately, I was shocked to hear that the authorities were arguing directly against their own rules. They said, no, 10 marks will go there. But the rule doesn't say so. Your own desire cannot change the rule. And like if your lordship wants not have the authorities to show that this statute has to be read not in its entirety, even not one single word, one single letter has a meaning that has to be completely followed. Today I will stop here. 2016 পাবে না তো বলে দিচ্ছি। There are authorities, I'm just not giving the, এটা দুটোর সময় এসে দেবো। May I stop it?
All right, you want to come back at? All right.
একটা বাজে আর পাচ্ছি কবে?
আজকে নয়, আজকে দুটো থেকে সাড়ে তিনটে।
For us, kindly keep it on Monday.
All right.
On Monday,
Let him make his submission.
Yes. But the other thing that I was suggesting, if somebody else, some other learned council wants to challenge the values of this rule,
It can be done.
they may
in one
all,
go.
yes, argue together. Let them conclude, then we'll make our submissions. Number one. And number two, I don't know whether Mr. Bhattacharya is seeking any interim order or not. No, I'm seeking you. In that case, kindly give us a week's time to come back with affidavits. No, but it has to be done by any means before 31st of December. No, but the problem is, unless pleadings are, your lordship can very well appreciate it will not end over here. Therefore, the pleadings must be complete. We'll take the shortest possible time your lordship feels would.
All right. You have the copy of the Supreme Court order, the last one.
Yes, the yesterday's one. Yes.
Yes, uploaded yesterday.
Yes.
The last paragraph of the order.
Yes, ma'am.
Yes, adversely prejudice. Yes.
As to what the High Court has to do, the court has mentioned.
Right.
untainted candidates in the past selection are allowed to sit for the selection test to be held afresh. How
Yes.
do you accommodate them?
Candidate, not.
How do you accommodate? You have set the eligibility score, the age in such a manner
Yes.
that some of the candidates are out.
No, 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 no.
Yes.
I like this. My learned friend has placed the rules in his own way.
No, not in his own way. The age, as has been fixed in 2025 rules.
Yes.
Right?
That is in terms of the Supreme Court's direction. Kindly have a look to the rules.
Rules.
Yes. Please have a look to the rules.
Take the rules.
Page 2025 tables, page 12. ये वाला? Okay.
But it's at page.
49 থেকে দেখি তো।
Yeah.
Para 49 of the Supreme Court judgment says
Began with
age
no
relaxation for the
relaxation.
untainted
That
candidates.
Yes, first, yes,
So
yes.
age is
For the
taken care
Honorable
of.
Supreme
Yes.
Court. And then
No,
Honorable
the Lordship may
Supreme Court
kindly
passed
take
an
a.
order and then relax that.
So age relaxation
right.
is there.
Yes, para 49.
Score relaxation. Score relaxation.
No, the Lordship may kindly take the rules.
Right.
Rule 3.
Right.
Is not for, my lord, with deepest of respect, my lord, not for the all the candidates who are the teachers. The candidates,
Right, right.
relaxation is not there.
Well, let there
One
not
thing
be any
let the
piecemeal argument. But I'll address your Lordship in its entirety.
Yes,
I'll
that is the
address
last order, that candidates,
Write
not the
question
teachers.
posed to him.
Yes.
Let him answer.
Yes. Yes.
Yes, he'll answer
The
because
real
this
sufferer
is
is the
the
waitlisted
direction of the court, Supreme Court on the High Court.
No,
So
no.
I just
Milord, only the
Officer,
last paragraph may not suffice. Milord, the other orders are required to be, Milord, please before your Lordship. Milord, in bits and pieces, Milord, it should not be.
not in bits and pieces.
Because
There
all
are
the orders,
matters.
Milord, all
may
the
not have
orders.
been served in all.
Sorry, I'm sorry, Milord.
You may not have been served in all matters.
No, I've made myself ready in the first matter.
Where the virus is challenged.
Yes, yes.
Yeah, I understand. But their commission will be there. They'll answer regarding some of the candidates. I'm getting matters who have been, who are not in a position to even appear in the selection test because of the 25 rules. How will the court ensure that they appear? Keep in mind,
Very good.
this is what is playing through the mind of the court, relying on what the Supreme Court has directed. Prepare. Commission is also here. They will also prepare. All right.
Milord,
2 o'clock.
two or three things, Milord, primarily, Milord, for the benefit of my learned friends, I'm submitting because on Monday they might add on to, Milord, what they have said today. Number one is, Milord, Supreme Court has fixed a timeline which cannot be extended by the High Court. Number one. Number two, my 2025 rules may be bad. Then also, Milord, 2016 rule will not revive. Neither will the 2019 rule revive. Because 2016 rule was replaced by 2019 rule. Now 2019 rule is being replaced by the 2025 rules. Therefore, even if your Lordship struts down, Milord, the 2025 rules, then also, Milord, 2019 will not revive, neither will 2016 revive. This is the second most important factor. The third most important factor is just the division bench judgment of Honorable Justice Shomensen's judgment. Milord,
Orunima Paul and Dolui.
yes,
Yes.
yes.
Dolui.
These are, Milord, would be very three important aspects, Milord, on which, Milord, I will address your Lordship, subject to the other ancillary factors.
So, my lady will hear the respondent side, untainted candidates on Monday. Is that the?
I do not know on Monday or not because the petitioner will start again at 2 o'clock.
Yes, my lady.
And the other petitioners also, I will hear them in one go so that the respondents
Yes,
can
that will be
answer
appropriate. Yes.
in one go.
For
And
us, keep it on Monday, Milord.
Maybe
provided they finish.
Provided they finish.
If they
Yes,
finish,
yes,
very,
I follow.
very.
Might go to Tuesday.
All proceedings are live streamed. I allow visual appearances,
Yes,
the virtual
I'm benefited
appearances.
from that.
So in case you are not able to come down, you
Yes.
can join
Or I
virtually
look forward
also.
to being in my lady's court physically.
That is
That
different.
Yes.
But then I cannot assure the
Of course, my lady.
timelines.
Of course, I
Right?
follow.
This is the reason I just
But in the
made my mind clear.
In the meantime, I also feel the prayer that made by learned Advocate General that now there are repetitions. Now, at least there should be some pleadings on our part also.
Pleadings,
So that Lordships allows us if
affidavit.
because I don't want it to be delayed in any
Listen,
some kind
it
of
1 minute.
Yes.
The hearing is continuing. In
Yes.
case anybody wants to prepare an
the
affidavit,
company.
please come, hand over copies
Yes.
so that they can meet
Yes.
your
Something on
objections.
record so that my lord
Very well.
become vulnerable
Because everybody knows the matter is not going to end here.
Correct,
Yes.
correct.
Right,
That's
it's
the
going to go up. So let the pleadings be on record. The court does not have any objection.
Yes.
But then keeping in mind the timeline that has been fixed by the
Lordship,
court,
continue.
I am continuing hearing.
Yes, my lord.
And in the meantime, you all can come up with your pleadings.
Yes.
Only
That's
one
very fair.
thing, appearing for the commission, now 18 is going on.
Cheryl,
18 and 25.
18 and 25. I was just wondering, which of the matters the petitioners are going to make 18 and 25 only. No one else. Anyone else from the petitioners?
One more.
As and when it comes up, take down note.
One
Right now, only 18 and 25 as
But one more technical aspect. The applications
Very
which
well.
are pending, Lordship may kindly have one formal.
you all have copies because all the copies are there in Sharthok. You all do have
that
copies.
we have. That we do not need only one line so that if there is a requirement for us to go up, if there is a.
There will be.
Then, my lord, no. What will happen?
Yes. Someone or the other
Now
will
then,
challenge.
my lord, because we are
Not-
now our technically our status is now we filed an applications, we are intervener and Lordship is hearing us.
I have
But-
mentioned in one of
Yes.
my orders that
Yes,
I'm
you are. We
hearing
are now
Division bench,
responding.
my lord,
We
division
were,
bench or the
in-
honorable.
Yes.
It might be.
I am hearing the interveners.
Yes. Yes, my lord.
It might be interpreted that Lordships have not allowed us to be a party. And Lordships is getting that the effect of it, in case Lordship takes the decisions against us, it will be extremely punishable. So all I want, one sentence, the applications.
In that case, all addition of party applications are to be allowed
27.
and formally added, and you can come up with your own pleadings.
Yes, yes.
All right.
Yes.
Today this order will be passed
Grateful.
after I hear
Yes.
টিম সরকারের আগের দিন যেটাতে ভুল ঘটেছে
all the matter.
18 and 25.
Already 18 and 20.
earlier day my lord, all the order kept in him sarkar matter, that is 27 my lord.
All right. All right.
But I
all right.
Just my note says 18, 19, 23, 24. 18, 19, then 27 is a 10-mark issue.
No. All issues are clubbed
All
together.
issues, if it is being heard together, then those matters may be kindly clubbed together and make comments hearing from 2 p.m. What I am respectfully submitting, all these school service commission matters are not same. Some of them will not assail the rules. Some of them say, when 10 marks are to be awarded.
That
Some of
also
them-
That
comes
all put
within
together,
the rule.
all
That,
together.
that group may kindly be clubbed. So that we all.
It is going on.
18, 20, and
Absolutely.
26
It
for
is-
now. 27. Very good.
Lord, the-
It is going on simultaneously.
18,
Please
24,
take
26.
note as and when matters are called.
Only-
I can
Yes, yes.
The
recollect.
only difficulty is my
Other matters
applications
also
are
implicate these 10 marks.
the entire series
Other
is
matters
from
also.
18 to 44.
Yes.
Now we have filed applications in like 23, 25, 26, 27.
Let it be
34.
called on.
Yes, my lady. Because even 23 implicates 10 marks.
Previous means
issue গুলো আমি প্রচুর ক্যান সব ক্যান গুলো
now which will be the lead matter?
Preemption.
You all have to decide. I do not know which is the lead matter.
Item
Find out.
I beg.
27
I think everybody understood the basic issues.
Yes, the rules.
That we have.
Mr. Lahiri's matter is a different matter. He say no person, his case is Untainted teachers claiming no contractual teacher should be getting any 10 marks. That is his case, subject to correction. No,
No, that's a contractual.
only the 10 marks issue, if it is to percolate, contractual teachers should not get. That is what I have gathered. Item number 41. If I am wrong, 41 is a different matter.
Teachers, they are, my lord, there is no.
First decide whether
Let
10
us
marks is there.
decide whether the rule survives.
Yes, madam. Yes.
And if the entire rule goes,
then there will be no requirement.
then
My point will be covered.
so let us wait.
Lordship, decide the
10 mark issue is there in the rule itself.
Yes.
Right? So
Take that 10 marks.
Yeah, it's fine.
all right, I hear y'all at 2.
Yes. My lord, I beg to mention, my lord, one.
My lord,
We have a 3:30 today.
my lord, may I segregate one thing? My lord will remember the EWS issue. That is item number 24. My lord, it will, my lord, from
Be
this
separate.
bunch, my lord, on
This will be
Monday.
separate.
Monday, my lord.
4.
No, 24 only.
My lord, I beg to.
24 on Monday, Mr. Bhattaji.
My lord, I-
24 on Monday.
Yes.
Item 24 on Monday.
Monday, because Mr. Bhattaji
All
has
right,
continued.
24 on Monday.
My lord, and my lord. Yes.
Sir, do not repeat prayers. I have heard. I have made what the court wants you all to know.
Understood.
24
My
on.
lord,
My lord, may I trouble your lordship with only one prayer? Your lordship might know, my lord, your lordship has been given the urgent determination of Justice Bivas Pattanayak, my lord.
Yes, that is what I have signed in the morning.
My lord,
my lord,
but
I.
it has come to one knowledge. I could not have mentioned at 10:40 because it was
Yes.
not put to Sabha, my lord. There is one
Yes.
urgent matter. Mr. Bhattacharya, I have talked to my learned senior. He will not take
Justice
more than
Basu ka
45
matter?
minutes.
45 minutes where? In this matter?
From 2 to in this matter.
All right.
He will conclude, my lord.
Ah.
Can it be little urgent? Last date
আজকে
is
তার
on
কার list আছে?
Tuesday. It was heard by
সেও তো বসেনি।
urgent
Yes, yes.
bench, my lord.
We gave that.
Just ordered.
Urgent determination based, and I have to pass order today, which will not be possible.
Otherwise, my lord, matter become.
My lord, urgent determination. My lord,
The law has been settled by 2 coordinate benches as well as by the division bench. Whether pursuing candidates can
Participate in the selection.
participate in test.
Arindam Mukherjee.
So, my lord,
100%
is the last date. Great.
Monday, you all can get it thrashed before the court.
Monday I will mention Tuesday it will be taken up.
I'll direct the matter to be there in the list on Monday at the top and mentioning your urgency so that the court
But
can
we
take it
will
up on Monday.
Implement the urgency because
my lord, I
there
am.
is already stated.
Well, it has to be listed. Your lordship only pass that order from the
All right.
My lord, I just give the number.
This will come up in the supplementary
Malad-
list today.
Oh, sir.
Similar.
Supplementary list.
My lord, Justice Pattanayak's.
1 minute. Supplementary. 325.
My lord, I have.
Grateful, my lady.
Where is the file?
My lord, I'll kept in 7. My lord, I just give the number, my lord.
My lord, I too am mentioning one matter of Justice Pattanayak's. My lord, item 3 today.
Extension of
My lord,
period.
extension. My interim order will expire on 30th, my lord. Today my matter was on item number 3, my lord. My lord, by the time the notification came, my lord sat, my lord, I could not, my lord, mention. My lord,
You
it's
can
an
get it done
urgent.
on Monday only.
30th, my lord, I am getting stripped of my
My lord.
interim order, my lord.
My lord,
Extension of interim order টা নিয়ে নিন।
Extension of interim order. একটাই।
um,
না, আমি ডিটেইলটা দিলাম, এটা মেনশন
My lord,
The other side should be here.
দিয়ে দেবে।
my lord, a similar matter. That is Mr. Bhattacharya, Mr. Dasgupta's special educator
জিজ্ঞেস
Hasan Mondal matter.